So you're here full time now. Mhm. But you're with the school system. You're not old enough to retire. Is it nice? Good. Oh.
You ready?
You go right. I'm sorry.
You ready? Okay. Good morning and welcome to First Baptist Missionary Church to our Women's Ministry Estate Planning Session. We're glad to have you here in the sanctuary and if you're watching on YouTube. The scripture says, a good man leaves an inheritance to his children's children, but the sinner's wealth is laid up for the righteous. Today, we are glad to have our attorney, Mr. Buxton, with us today to give us some information on estate planning. We are looking forward to it. It's something that we all need to have information on. Before we get started, let's just say a word of prayer, please. Today, we give our hearts, our minds, and our lives. Come speak your words to life into our beings. We pray that you would deepen our comprehension, broaden our thinking, and transform our understanding of what we are about to study, about to hear. For you are our wise counselor, our perfect teacher, and our faithful friend. Thank you, Lord. In Jesus' name we pray. Amen. Like I said, we are delighted this morning to have Mr. Buxton with us to give us some information on estate planning. And so without further ado, we bring Mr. Buxton forward. Thank you.
Thank you, Ms. Blanding. Good morning, everybody. On Saturday morning, I hope that the weekend has started off great for everybody. I'm going to, I need to turn this off. Like she said, my name is Bill Buxton, and I'm with Curtis and Croft over on Calhoun Street. And when Miss Graham asked that I come speak, invited me, I said, absolutely. I think everybody needs to know about estate planning and the importance of it. And the four documents that are most important in estate planning that I'm sure everyone has heard of are wills, power of attorney, healthcare, power of attorney, and a deed. And today I wanted to start off by talking about wills. And under South Carolina law, what is required in a will? 1, you must be of sound mind and over the age of 18. 2, the will must be in writing. And 3, it must be signed by you and 2 disinterested witnesses. That means no one who will be a beneficiary of your estate or your will. One of the most important of those requirements is sound mind. You need to have the mental capacity to know what you are signing. A will accomplishes 2 objectives. 1, a will allows you to dispose of your property as you wish, subject to some exceptions. And 2, it allows you to nominate a personal representative to administer your estate. That's who you select to manage your estate once you are no longer with us. The personal representative it's important to have 2 people in mind for this role, a first choice and a second choice. That's what the probate court always asks. Is this echoing a little bit? Can y'all hear okay? And I'll just wait just a minute. We have a few people coming in, and I will hold off just one minute. Everybody get seated. Good morning. I had just begun speaking about wills and the requirements of a will and the importance of a will. So a personal representative is somebody you designate through a will to handle your estate, We always want a first choice and a second choice. The first choice is typically a spouse, or it could be an adult child, somebody that you feel comfortable with and that is responsible enough to handle your estate once you've passed. But the personal representative is one charged to collect your assets, pay your debts and funeral expenses, and to distribute your property as provided in your will. If you have no will, then according to the intestacy statute, the personal representative must be over the age of 18 at the time of an appointment. You can change a will at any point or revoke your will as long as you are of sound mind. If you have a will, you should not write on the will or make any changes. Such writing won't make that change effective, according to the court. In our wills, we reference any real property, which would be real estate, and we reference who the PR selections are, and we also reference a written memorandum. In the will, a written memorandum is something where you would distribute your automobile, jewelry, furniture. You can change that memorandum out as many times as you change your mind without changing the will. The important thing is that will stays very basic. If you wanted to say leave your great-grandmother's earrings to a granddaughter, we'll put that in there if you're never going to change your mind. But we don't want to change that will repeatedly. And my rule of thumb on wills is to, if you have one, reevaluate your will every 10 years or every life change. What is a life change? A life change is marriage, divorce, retirement, relocation. All of those big life changes, just make sure it reads the way you want it to read. When people come in to execute these documents with me, I collect the information, and I provided some forms here today if anybody's interested in having these documents executed. But I have everybody read the documents. I step out of the room. I don't want to hover over your shoulder. I want you to mark it up. And if you have questions, you ask me. There could be some legal language you don't understand. It's your documents. It's your estate. It's everything that you've worked hard for, or your family's worked hard for, to make sure that it is distributed the way you want it to be distributed. I can talk briefly about a divorce. Under South Carolina law, automatically revokes all of the will provisions once you've divorced. If you make a will and you subsequently get married, it's possible that your new spouse will be entitled to your entire estate, or at least half of your estate if you were survived by children. There's something called the elective share. In your will, you can give everything you own, including land, automobiles, household items, and money, to anyone you choose. However, if you were married, under the South Carolina Elective Share law, your surviving spouse has a right to claim as much as 1/3 of your property that's disposed of you by your will, if the new spouse is not mentioned. If you leave less than 1/3 of your estate to your spouse can claim additional property equal to the difference between 1/3 and the amount bequeathed to your spouse. The elective share can always be waived. But I want to talk about what it is to not have a will. Without a will, what could happen? Without a will, your property and your surviving family's affairs will be governed by the choices reflected in the state law of the state of South Carolina. Dying without a will is called dying intestate. Intestacy statutes favor your relatives, and the closer the relations, the greater the share of the estate. Without a will, obviously, if there are assets to be disposed of, it would have to go through probate. And this is where I start getting into talking about different documents. Everybody's heard of a deed, right? It's a title to real estate. If you own real estate or your family owns real estate. If you're married, and not always if you're married, you could have a joint deed with a child. But we always include language that says Harry and Sarah Smith, joint tenants with right of survivorship. What that means is if something should happen to Harry or Sarah, all of that ownership in that property goes straight to the survivor. It does not go through probate. That's why a joint with right of survivorship deed is so important. And it is any property, but it's filed over the register of deeds at the old courthouse, and you don't have to worry about going through probate. Things that do go through probate are things that are titled solely in your name. My father passed away in 2003 in Charleston. He grew up in Sumter, but he passed away in Charleston. And my mother, 11 years younger, she just turned 82 a couple of weeks ago. She took care of all the estate. We had an attorney handle it, and it was about 3 years later that we thought everything was done. And she was still grief-stricken. But he had bought a new car a few years before he died. He'd gotten sick, and it happened rather quickly. She kept that car because for security purposes. If anybody came by the house, she wanted to see there were 2 cars there. About 3 years later, she said, I think I'm ready to give that car back to the dealership. I don't want it anymore. And they said, sure, we'll sell it for you. They go to sell the car, and his name was on the title. And they had to reopen probate and probate that half of an automobile, which set her in a tailspin. But you got to look at these titles. If it's a car title and you're married, have it say or. If it's and, then 50% of that automobile will have to go through probate. 2 different probate estates. If it says and, it'll have to go through probate. So it's 50% one spouse, 50% the other. If it's or, it gives you that mobility to change it. Unlike with a joint with right of survivorship deed, that's automatic to the surviving spouse, no probate. The real estate deeds are even more important because you'll see without a will, I always use the example. Has anybody heard of heirs property? Heirs apostrophe. In law school in Charleston, I worked for the Center for Heirs Property Preservation, and they're the only outfit of their kind in South Carolina. And I always tell this story because I found it fascinating. I went there and I was volunteering but getting a lot of experience on doing quiet title actions, and we would have cases where, say, a couple, they married, and a young couple, and they had some probably quite a few acres along the coast that they would farm, and they had 5 children, raised those 5 children. 1 went to New Jersey, 1 went to Ohio, 2 stayed on the land, 1 went somewhere else, but those 5 children had 5 children each. We're talking 25 grandchildren now. They're getting spread out everywhere. But that original couple, neither one had a will, and they never did anything about the deed. And so people come to me and say, what do we do? How do we clean this up? It's tough because you've got to contact everybody, give everybody notice that you're going to quiet title to the land. And those are big cases because you've got to track down all the family members. And I think the biggest one that I worked on was about 112 family members across the country. What about the ones we don't know about? What about the children that were born outside of marriage? So we have to run a publication notice in the newspaper in the location where the land is situated. Those are tough cases because they take a long time. The more family members you have, obviously, the longer it's going to take. But what we saw started happening probably in the 70s and 80s was all that land that nobody wanted, that couple got, where was that? On the coast. Mosquitoes. Nasty. Nobody wanted that land. It's hard to farm. Somebody from Atlanta comes in and says, hey, who owns the land? Oh, my grandparents did. Well, we can help you. We'll pay you for this land. And they sign a quitclaim deed over. And that's a small amount of interest that they sign over to that developer in Atlanta. They bring the quiet title action because they have the money to do it. They get the land, pay a minimal amount, and then they develop it into a resort. It's terrible. These families lose a very valuable thing that all of them have worked hard for. We don't like to see that. And so the Center for Heirs Property Preservation, we'd go and we'd protect those families. And I would go around with the attorneys. This is before I was officially attorney. It was my last year of law school. And we would go in churches in North Charleston, Somerville, different areas, and Johns Island. And we would speak about the importance of all of these documents we're talking about today. How we can try to save those things from happening. People don't like to say stealing the land, but we see what's happening there. And it's being taken advantage of because people don't have these documents. They don't understand the documents or don't know the documents. So with that, I'm going to talk a little bit about the power of attorney. And we can go back and revisit any of these documents any time. With the power of attorney, all of these documents are important because you have to be of sound mind when you make the documents. And that's what we do at our office. We have a notary and I have one of my paralegals. We witness the documents and you're done. I say put everything in a safe place and don't worry about it unless you want to make changes. The power of attorney, you've heard of. Everybody's heard of the power of attorney. Everybody thinks, oh, I don't need that. Well, I think everybody needs one, especially if you own property or anything. Really, what you're doing is you're giving that power, that authorization to someone else to sign your documents, access your bank accounts, and make payments on your mortgage if you need to. Anything out there, they will step in your shoes and handle your affairs. Typically, I say, all right, let's just execute one and give it to your spouse and go put it in a safe place. The important thing is that you've executed it, you know what you're signing, and you're of sound mind. I'll just tell you what happens. You put them up, right? You put them in a safe place. If you need to use it, you go file at the courthouse. $25 to file it at the Register of Deeds. Then it's activated. It gets a book and page number, just like a deed, and anybody can go online to sumtercountysc.org and go to the ROD website and see that you've given power of attorney. It's recorded. They have the authority to sign. Go to the bank for you. Even the banks can look it up. We can revoke it if it's just a temporary one or you don't need it anymore. But if you don't have one, that's what I worry about for people, is if you don't have one, then you're going to have, and you're not of sound mind, say, unfortunately, Alzheimer's, dementia, it's all bad examples. I don't have a positive example. But if you don't have that mental capacity, then you have to go through the probate court and petition for a guardianship and a conservatorship. A family member would do this for you, but those get expensive. By statute, you have to have an attorney guardian appointed. You have to have a doctor that will fill out certain forms or come testify. All the family has to be notified. If one disagrees, we're having a hearing and find out what is in the best interest to do for this individual. The court has to approve it. You can imagine that probably gets pretty expensive. With a power of attorney, go file it, and you avoid all of that. So it's an insurance policy in a way. I don't suggest people file those right away unless they need to. I know my mother executed those documents about 5-10 years ago, and I have a younger brother that's an attorney at Charleston. He has the healthcare power of attorney. I have the power of attorney. She said, go ahead and file them. I don't care. I can take care of my own affairs, and when I need you, I'll let you know. So she wanted them filed. So we feel better that we haven't filed. She's a widow. But I think you don't have to file them unless you're ready to file them. I use one example. It's kind of a silly example. But I say, well, you need to have that document. Your husband, your wife, your adult child, just go put it somewhere, because if you're traveling and say you're going to be gone for 2 or 3 weeks, visiting family, wherever you are, and someone comes and knocks on your door and says, hey, I want to buy your house, and I want to buy it for $1 million, but I want to buy it by the end of the week. You can't get back in time. You tell your spouse, wherever you designated that power of attorney, go file at the courthouse, sell my house, and I'll be back. And we can revoke that power of attorney later. It's kind of a wild example, and it's not very realistic, but it's something that's more positive. You want somebody to be able to take care of your affairs that you trust and that you know what's happening. When you get back, we revoke the power of attorney and do a new one, put it in a file cabinet, safety box somewhere else if you don't need somebody signing for you. The probate process is very long and extensive. There is something called a small estate administration, and that's anything that's $25,000 or less. The complete value of your estate is $25,000 or less. They can open and close it within 48 hours. That would say a car. We'd have to identify the VIN number, and we have to identify the account of the bank or whatever it is specifically, but the value has to be less than $25,000. If there's real estate involved, or it's above $25,000, it's going to be about a year process, because you've heard about the creditor's claim period. I don't know if anybody's heard about that, but when an estate is opened, it runs in the newspaper 3 consecutive Sundays or Saturdays, whenever they run it. Notice has been given to everybody out there that an estate has been opened. This is the personal representative, and if an attorney handling it, this is the attorney handling it. Creditors have to make a proper claim against the estate, whether it be medical bills, credit cards, or whatever. If someone passes away and credit card bills come in their name, don't do anything with it. You're not responsible for that. And those creditors have to make a claim properly against the estate in probate. So I always tell people, if I'm handling the estate, bring me all the bills. I will recognize when it's a valid claim, and I will deny it. If there are no funds, I'll figure out a way to handle it. Don't pay those credit card bills if it's not in your name or name of the state. We'll figure it out from there. If it's a valid claim, then we'll address it properly. A lot of times you'll see that people paying the credit card bills and say, no way, that's a collector from Minnesota, and they're trying to collect $10,000. They're not going to send an attorney to Sumter, South Carolina to collect $10,000. Now, $40,000, $60,000 they may. They're not going to spend that money. We can deny those claims. They have to do it properly. It's a 9-month creditor's claim period, and that's also, we can't transfer any real estate through a deed of distribution until those 9 months have passed, unless we get approval from the court to do it prior. Does anybody know why it's 9 months? It's not a trick question. Anybody? What happens in 9 months? You have a baby. So it's all based on old English law back in the 1500s. Is that it was 9 months because after 9 months, we will know if there are any other heirs out there. If anybody else has been born, we'll know after 9 months. So that has evolved into the current day creditor's claim period. And it's funny, you have these little quirks, but nobody really knows it, and I didn't know it until I went to law school. But it's their way of handling those creditors' claims. It's a long, tedious process, document intensive for the probate. And even if you have a will, you want to make sure it all goes properly. They're going to follow that will to the T. We always, everybody always worries about, well, I've got these children, but I got this one that I'm not so sure about. They're going to cause some problems. I think everybody's heard about these stories. And so when I tell people, I said, well, okay, that one, I know you've helped them out and you've given them a lot. And I said, but we're not going to leave them out of the will. No, we need to mention all the children, and we need to mention that one. We'll give them $100, or we will say, John has been taken care of outside of this will. We have to address them. If we don't address them and we don't recognize them, then they can make a claim saying, hey, they forgot about me. I get some of that. We don't want that. We don't want that. And I don't want people to ever feel guilty for cutting somebody out of their will. That's not what it is. You're not cutting them out. You've already provided for them during their lifetime. You've helped them out. That isn't fair to the other children. But everybody's different. They're going to handle it their own way. I had one older woman come into me, and she was so angry that her daughter hadn't come up to visit her from Florida. It had been a year. And she said, I want you to write in there that she is dead to me. I said, no, I'm not. I said, because she's going to have to live with that once you're gone. I'm not doing it to anybody. I'm not saying why. No, we can say you provided for it, but I'm not. That's just an aftermath, a lifetime of heartache for that woman, or the daughter. I just wasn't going to do it. So, talking about the power of attorney, I think everybody understands that. Do you have questions about a power of attorney? Maybe we'll just talk about each document. If you have questions, anybody have a question about a power of attorney? Durable power of attorney. All right, well, then we'll go to the healthcare power of attorney. Let me talk about that. It's also called a living will. The healthcare power of attorney and living will are the same document. We combine them. And it is just the same way. You're giving someone that authority to talk to medical providers, doctors, whatnot, nurses that can access your medical file. You've heard of HIPAA. And it says the restrictions are crazy now, and sometimes they'll let a spouse talk, but with the healthcare power of attorney, we don't file that one. We just say, hey, give a copy to your primary care physician. They'll get it into your medical file. Anywhere you go, they should get it in your medical file. If you go into the hospital, you sign forms about a healthcare power of attorney, or do you have one? Do you have a living will? The living will is where you've probably heard of this, but you have choices. And it says, I want tube feeding. I don't want tube feeding. I want my agent to decide about tube feeding, or you say what you want in your own words. I don't want any life-sustaining treatment. I do want life-sustaining treatment. I want my agent to decide. So it gives those choices and they're clear. If the family ever questions, you see exactly all the choices you were given and you're going to choose one and you're going to initial there. So there's no conflict. We know what you want. Everybody knows what you want. It's in your medical file. You don't want to have those going on if you're in the hospital and you can't think straight. It's the last thing you want to think about. That's why these are important. You don't have to think about them once you've executed them. That's how the healthcare power of attorney and living will operate. So I let everybody keep the originals. I tell them, keep the originals in a safe spot. I make copies and say, take this to your next physical or your next doctor's appointment. It's also, the living will is also referred to as a declaration for of desire for a natural death. And it gives, what do you want? Do you want that treatment? Do you want that tooth feeding? Or do you not? Or you don't care? Let your agent decide after talking to doctors. It spells out what your desires and wishes are. And that's what's most important. It's you. When the other people making these decisions, well, what do they want? Well, they said they didn't want anything. Oh, all right. Let's talk about that. Are they going to pull through this? We don't know. Let's give it some time. It says in there. You can read it. And if you don't understand it, I explain everything. I want you to read them on your own. People get confused, but that's why I'm there. If I step out, circle what you don't understand. I'll come back and answer it. And you don't have to talk about it or address it anymore once you've taken care of it. That's the good thing about these documents is that once they're done, they're done. We can change them later, but at least you understand them and you know what you've done. You're taking responsibility for your own life, for everything you've worked hard for in your life, and trying to prevent any bickering among family members when the day comes. And the day comes that it's just a power of attorney. You haven't passed away. You get better. You're going to be fine. But you still don't want the bickering going on. People change when somebody passes away. You'd be surprised. And the bigger the family, the more likely that there's going to be something going on. No one can revoke your power of attorney or healthcare power of attorney except yourself. And if it got to litigation, you got to go to the probate court. Judge is going to go through that. It's not a bench trial. It's not a jury trial or a jury hearing. Right. If it's a contested will, though, if somebody says that's not the signature or that's not their will, those are very long cases. They're tedious. You have to get handwriting experts. I don't have the resources to handle those cases. And when someone comes and says, that's not Mama's handwriting, I know it's not, and I don't recognize any of that. So you're going to contest it? Because if you want to contest it, I can find you somebody in Columbia, Charleston, or Florence, because it's going to be a long time. You're going to get handwriting experts that are expensive, doctors, expensive. I don't have the resources to handle a will contest, and it just gets muddy. I've done a couple of them, and they just get really awful. But it happens. Let's see. I spoke to you all about deeds, so everybody understands deeds, real estate deeds. Any questions on those? Joint with right of survivorship. There are many different kinds of deeds. Typically, you'll see tenants in common. That was before we started putting in the joint with right of survivorship language, which started probably around the 90s. The older deed I find, tenants in common. That's where we have a problem when somebody passes. They're coming to me. How do we fix this? That's what we got to probate 50% and do a deed of distribution where we show we have to trace that title. Where we show it goes from those two. From the probate estate, that 50% goes to the surviving spouse, or however the will reads to the children, however. And without it, it just gets messy, and that's when we get into heirs property. It creates a lot of problems, and you'll find heirs property everywhere. It's not just farmland or maybe even 2 blocks away from here. You'll see where they've developed a neighborhood Walmart, and then a shopping center over here. But there's this little house in between, and it hasn't been touched. That little house, I can guarantee you, I'll look up the deeds, and it's going to be owned by about 3 different generations of the family, and they can't come to an agreement. And they probably could have made a lot of money if they did. Everybody thinks they're entitled to something, and they are. It just depends on the value. It depends on how old the deed is, how many generations we have. I'm kind of jumping around here, but a quiet title action that I mentioned before is where we're quieting title to everybody who has an interest in this property, known and unknown. A partition action is where you're not going to quiet title, but you are going to say, okay, who owns what share? Well, I've been paying the taxes for 20 years. You'll get a credit for that from the judge, but it doesn't mean you own it. It doesn't mean you own it. And so they go through and they see who has what ownership interest, all the way down to, say, great-grandchildren. Problem with that is if you have minors, then it's a whole other mess, and we won't even go there unless you all want to know about it. And I give examples. I had an older couple come to me. They had both been divorced and remarried. They were probably in their 70s or 80s. And this was probably sometime 2012, 13. And they had two houses from, I guess, their different marriages they ended up with. And one was a newer house in a development out 441. And another one was right on Wachter Street. And they said, oh, well, we want to give the Wachter Street house to the grandchildren. We have 4 grandchildren. And I said, well, how old are they? They said, well, one is 21, one's 23, one's 4, and one's 6. I said, okay, we can do that. I don't recommend it. So we're just going to rent it out, and that will be for them. And when we pass, that'll go to them. I said, all right, and you're going to live in the newer house, and I get it. I said, we can do that, but the problem is if you ever want to do anything with that house, if you want to refinance it, if you want to take out a home equity line of credit on that house, if you end up wanting to sell it, those 2 minor children are going to have to be represented by a guardian ad litem, and there will have to be a conservatorship set up in the probate court, so their interests are protected because they're on the deed. No, that's what we want to do. We've decided. All right. A few years later, they came to me, and what happened in 2015? Big flood. Flooded out this nice new home in this development they had. And they said, oh, it's going to be a mess. I think what we're going to do is we're just going to try to let insurance deal with that. We want to move into the Wachter house. And so we just want to change that deed to the one over there, the new neighborhood. We don't want to live there anymore. We want to move into the Wachter house. I said, remember when I told you? I said, we can do it, but it's going to be mighty expensive. And I told her what all was involved in getting guardians for the minor children, because they were still minors. They might have been 8 and 12 by then or something. But I said, no, we're not going to touch that. Because once they're on a deed, they have an interest in ownership. And so I said, you can do it, but they decided not to do it and keep things the way they were. So there are different deeds, but I just always say be very careful how you deed it. I want to put my children on. You don't want to put anybody on that deed unless it's your spouse, which one right survivorship. Even if you say a life estate, you've heard of a life estate? I'm going to keep the house in a life estate with the contingent remainder to my children, which means it's yours as long as you live in it. Once you pass, it goes to the children. Well, that's good. It helps avoid the probate, but it also limits your mobility on your asset, which means you have equity in this thing you've been paying for. And if you go to refinance it, sell it, or anything else, they're going to have to be there to sign at that closing or the refinance. So it limits your mobility with your asset. I always say be careful what you're doing and how you do it, and understand what you're doing and the implications and ramifications of involving other people on these assets and titles. Yes, ma'am, please. You can do that. Are you talking about real estate, real property? Mm-hmm. Prior to your passing? Well, is it your primary residence? So it's something else that you own, and it's in your name. You can do that. You can do that by deed. We do that all the time. That would be a quit claim deed. Quit, Q-U-I-T, quit claim deed. So when you give that, transfer that deed to them, and keep in mind, when it's a family transfer, whether it's husband, wife, children, we put it on there as a family transfer. There's something called an Affidavit of Consideration that is behind every deed. In a typical sale, a buyer and seller, we mention that price. You've heard of deed stamps or transfer tax. The seller of the property is paying $3.72 to every thousand, in the purchase price. That's the transfer tax. The county charges you that. Deed stamps, transfer tax, it's the same thing, but a seller gets charged. That's not the same as your property taxes you pay every year. That's in addition to, it's a transfer tax, and the seller has to pay that. If you're deeding it to family members and your children, well, we put a family transfer, and it's not taxed. We say love and consideration and $5. So it's not taxed by when you transfer to family.
Okay.
Does that help?
So is it better for me to, don't find the way I'm gonna say this. Is it better for me to pass away, then they get it? Or is it okay before? Because I got it before. My dad took care of all of that before he passed away. So we got everything set up. He set up everything. So
Smart.
put all of everything. So should I do that? I'm not gonna surprise him with that.
The things I consider in doing something like that is, one, the value. Are you going to be taxed on it if it's part of your estate and it's still in your name?
Yes.
And so typically we take, if you look on property cards the county has, we take the county value. And if the family is disagreeing, then we have to get appraisers, real estate agents, and what would the property sell for? Now we just take the county value. That's if you've passed away, and they've got to calculate the probate tax. It's a sliding scale based on the total value of your estate. That would include another house or your bank accounts, anything that has not been designated where it's going to go. Let me just talk about bank accounts and insurance policies and investment real quick. It may help you. If you have a 401k, if you have a banking account, savings accounts, ask your banker or whoever manages these accounts, have you filled out your beneficiary forms? Have you designated who your beneficiary is? Is it going to be your spouse? Is it going to be a child? Make sure those are filled out. Those are POD, payable on death. They don't go through probate. They go direct, and they're not taxed. And I always tell everybody, make sure you have your beneficiaries designated. If it's a joint account, make sure it's joint with right of survivorship. All that passes outside of the probate. With what you're talking about is, if you don't want to use that land as collateral, say, all right, I'm going to put a mortgage on that so I can redo my kitchen over here or whatever. It depends on how your lender wants to handle it. You won't have that mobility to do that with that property anymore once you've deeded it to your children. Okay? That's, and you think about, okay, we have responsible children. Do they all get along? How many? I hate to see it when we go to probate and we pass a deed to say 9 children. That's going to be tough somewhere down the future, and I don't want to be a part of that one. And sometimes they'll just, the children will quit claiming back. They'll say, Mama, she's the one that's surviving, and there wasn't a will. Or one child will say, I'll pay y'all for our portion. Let's be fair and reasonable. And I get involved in those. I'm representing the estate and helping the personal representative. But when it comes to squabbling, we try to really work things out as much as we can. But inevitably, somebody always thinks something's worth more than it really is. We see that all the time. But you could go ahead and do that now if you don't want to use that asset. Transfer it to them now, and it won't be part of your estate. It'll go straight to them. I see that happen quite often.
As far as where it's located, does it matter? I mean, are the rules that different tax-wise?
Well, that's a really good question. So I deal with, I only practice in South Carolina. I only have a South Carolina license. But sometimes I can't tell you how many times I've dealt with estates that I've had to open here in Sumter County, or Clarendon, or Lee, Williamsburg, and it's somebody who lives in New Jersey. And it's family land. And I'm working with an attorney in New Jersey. I say New Jersey because I'm doing one right now from New Jersey, where it's land down here, and they know they have it, but we have to open a probate estate. Did they have one open in New Jersey? If they did, I need to get an exemplified copy and come down here and open one here so we can transfer that land. So other states, under the full faith and credit clause, will recognize our wills. If there's nothing up there to probate, then we open down here. We need a death certificate, an original death certificate. If there's a will, we need that original will. But we open the estate here to probate the property and have it pass the way it's supposed to. We've heard of chain of title in real estate, or chain of title. When we go to, say, close on real estate, on a house, we do a 40 to 60 year search through all the courthouse records. And we make sure that that property is passed properly to each person, however it goes, the chain of title. If there's a defect in the title, we have to cure it. Now, what's a defect in title? A defect in title is a tax lien, a judgment, a divorce due to the property transferred by that divorce order. It could be an easement that wasn't recorded, or it could be anything. We've got to make sure that whoever's purchasing that property has a clear and marketable title. So what they're getting, they're not inheriting any liens, they're not inheriting any judgments. Those all must be satisfied and taken care of before the property properly transfers. And if they have a lender, the bank wants to make sure that that's been taken care of too, because they're letting you have a mortgage on it. They have an interest in that real estate until it's paid off, and they want to make sure they have clear title. So we're clearing title. That happens in heirs property. We're trying to clear the title so that land, the property, has the true value that it really is worth. If it's clouded, if there are clouds on title, which means, that couple that bought the land in John's Island or by the water, they never had wills or deeds. That's a big cloud on title with all those people involved. They all have an interest. And the only way that you can determine a true interest in, say, a partition action is have a judge determine that if you're dealing with multi-generations. Because inevitably there's somebody missing, or there's somebody who's predeceased and had children. We got to cover everybody and do the family tree. And that's what I find fascinating, is doing the family trees for somebody I don't know, because I've got to write it out and it summons a complaint. So when you read it, you can understand who the original couple was, and where they died, and when they died, who their children were, if any predeceased, who their children were, where they lived. I got to go through all of that, which is why it's so time-consuming to do quiet title actions and clean up title. Sometimes it's just simple with, say it's just a tap clean. We can pay that off at closing. Those kind of things. It sounds tedious and horribly boring to y'all, I'm sure. But it's part of what we do, and we want to make sure that, if you're purchasing it, we're not going to have you inherit any liens or judgments or any clouds on title. We want to make sure that you're going to get the proper value, so you can turn around and sell it and do what you want to do. You're going to get the value of that property at full value.
Is it better, and not that I'm thinking about this, if, say, I decided I'm single, if I decide to get married again, and my spouse and I, future spouse and I, decide to, he has kids as well, and I do. What is safe to do in that situation to keep everybody from killing each other once we both pass away?
It's a really good question. You see it a lot. What I do in a situation like that is I tell people, all right, have you adopted your stepchildren? That's first and foremost. We got to give that consideration, because an adoption makes them a legal heir, as if they were your own. If not, and they're just step siblings and stepchildren, let's go ahead and just spell it out in that first paragraph. My name's Cynthia Graham. My husband is so and so. These are my children, and these are his children. The purposes of this will, they will all be treated equally in inheritance. Or these are my children, and everything will go to my husband, and if he should predecease me, everything will go to my children, and I list which ones that goes to. So, especially if it's a remarriage with children involved, we need to address them all. So if they ever argue, they can go to that will and say, oh, that's what she wanted. Okay. And you have to think about that. I just did an estate, went on for 3 or 4 years, where it was a remarriage. And the man had moved down here from Virginia, and he had done very well in Virginia. And he probably had $300,000 in the bank, maybe because he was retired, and he had these accounts. When he came down here and everything was so cheap, he bought his house outright. He remarried, and in the will, he said he left his daughter $30,000. By the time he died, there was no $30,000 to give to the daughter. And the two PRs were friends of his, not even related. And they said, well, we got to come up with $30,000. And here I have the surviving spouse, wife, who was the second wife. And she said, I don't have $30,000. And she's finishing paying the last little bit on the mortgage, paying the taxes, the insurance. She's driving automobiles that are in their names. And they said, well, she can sell the Mercedes. And enforced it. But we call that a lapsed gift. A lapsed gift. Because he made a gift, he spent all his money, and he didn't have it to get. It wasn't there when he passed away. And that's why you reevaluate your wills to make sure they say what you want to say. But we ended up, I think what we did was she was able to come up with, I think, 5,000, give her something. They got along. It's just that we didn't have the 30,000. It's not there. It's not there. So what do? Are you going to force this 75-year-old woman to go sell the automobiles that may or may not gather that much money? I don't know. It's just, it gets tough in situations like that. I don't like putting specific requests in a will because we follow that will. You can put it in your memorandum that I spoke about earlier. If it's there, it's there. I give John my 2021 Mercedes sedan. Well, now it's 2035, and there ain't no Mercedes sedan. It's a Toyota Corolla. Does he get the Toyota Corolla? No, because it didn't say. See, I kind of follow that.
Yeah.
So when we get specific in those wills, I don't like that. I like to keep it loose in general, and we reference the memorandum because you can change that memorandum anytime you want without changing the will. That's why it's so important to have these, because even if you forget you have a will, let's hope it says what you want it to say. Just reevaluate it, make sure it reads the way you want it to read. But let's have some ability in there and keep it general. It's important. That's why we also ask for 2 personal representatives, a first choice and a second choice. That first choice could be your spouse, or they could predecease you. At least we have a second choice. Or say it's the spouse. They're so grief-stricken, they don't want to deal with probate case and all that mess. And they'll have an attorney, and I don't want it. We have a second choice, and I work with that second choice then. And you give me the information, I'll prepare the probate documents. And that's really how we go until we can administer the estate and be done with it. It's just so important. I was telling Ms. Graham earlier that I've had more people come to me beginning March of 2020 when that whole quarantine started just to do these documents. And I said, good, this is great. I don't know if it was fear. We've all been placed in fear over the last year and a half. And not a normal fear, a strange fear that we're used to. But we want to make sure that, hey, okay, my fear is I don't want to get sick. I don't want a family member to get sick. I don't want to lose anybody. Let's get these things taken care of. And we don't have to think about it anymore. It calms some of your fears. It takes that anxiety out of what happens, what if. You got to have these in place to avoid those things. And then you can relax a little bit. Nobody wants to talk about this stuff. Nobody wants to address it. But once it's done, it's done. You don't have to talk about it anymore. Is it painful to talk about? Sometimes it is. Oh, I didn't realize I really don't want to leave her anything. Just be honest with yourself. We'll word it right. And nobody needs to see these documents. Nobody needs to see your will. You're going to keep the original. I'll keep a copy at my office if anybody ever needs it. But the court's only going to accept the original one. And so I tell people this is personal stuff. It's up to you how you want to handle it. But you've worked hard, or your family's worked hard, whatever you have, you want to make sure it goes where you want it to go. We can't control from the grave. And we can't say, hey, I want this piece of property to stay in the family forever. It's not going to happen. One day that may have been in your family for 120 years, and one day that property is going to go out of your family. And it's just the way we are. It's the way it's going to happen. We can't control it from the grave. We can control it for so much time, and that's called the rule against perpetuities. I can't even begin to explain that because it's very complicated, and I don't want to get into that. Even I have a hard time going through that statute. But I was going to read you. I did have this, and I didn't want to start with this because it's the South Carolina intestacy statute. I'm going to read it to y'all, and y'all just tell me if you understand. All right? This is kind of how it works. If there is a surviving spouse and no surviving children, then the spouse takes the entire estate. If there's a spouse and children, the spouse takes half, and the children divide the other half among themselves. This is without a will. If there are children but no spouse, then the children divide the entire estate among themselves. So if it's just you and you have 5 children, your estate will be divided 5 ways. Even if one of those children, well, we're getting there, if a child predeceased the deceased person, so now there are only 4 children. But the children or other lineal descendants, we call issue, if you have issue, of the deceased person, say grandchildren, then the issue take their share, which means if you have 5 children and one predeceases you, say each children have 5 children, your estate's still divided 5 ways, even though you lost a child before you passed. Those 5 grandchildren are going to take 1/5 of your estate. So it's still that there's one representative. That child that predeceased you is going to get that 1/5. That family will get 1/5. If there is neither a spouse nor children or any other issue, any other relation, the estate will go up. It'll go up to your parents and look at that generational level. If there are none there, then to grandparents. So it goes down, nobody down there, starts going up. And then to great grandparents and so on. There's a term called escheat, E-S-C-H-E-A-T, escheat. And I don't know if you've ever heard of the term, but if they can't find anybody anywhere, then that estate eventually will escheat to the state of South Carolina and everything. But they don't want it. The state of South Carolina doesn't want it. They do not want it because they don't want a family member coming back a year later saying, wait a minute, nobody notified me. Everything has to be done so properly that they don't want to get involved in all that. So that's the last thing happens, is that those funds would go to the state because there's nobody anywhere. People always have questions, oh, the state wants the state. They don't want to deal with all that. So that's the last thing that happens if there's nobody out there that could inherit. Do y'all have questions? I'm kind of going randomly, but yes, you have some great questions today. You do. No, it's wonderful. There's no stupid question. There is no stupid question.
So, thank you. So, you have an uncle or an aunt. Okay. Uncle or an aunt that pass away. They have no kids or spouse, and you get a letter in the mail saying now you are the proud owner of all this land and whatever else they have. So, and I'm making all this up too.
There's some strange scenarios out there.
Yeah, really. So say, and I'm not sure if this is going to be what I want, the answer I'm looking for. Say if they owe taxes or whatever on the property or house or whatever. And like I said, you get this letter and you're like, okay, this is cool. But then you see that there's taxes. What happens with that? You're not prepared for anything in a situation like that, maybe. So what happens?
Sometimes inheritance can be difficult. Those taxes got to be paid. They don't care. The government doesn't care who pays the taxes. They got to get paid. If you want that property, you're also going to assume those taxes.
So what it would just go to someone else or just keep going?
No, it depends on it. It depends on if they had a will. If they said you're going to be the one, then it goes to you. Taxes usually would be paid through the estate, but once it's in your name, you have responsibility for that. So, I inherited 70 acres in Sumter County. Well, that's great, but you still got to pay the tax bill.
Right.
I tell people when someone passes, well, the mortgage wasn't in my name. I didn't care. I just care. So they're getting paid. So it doesn't mean you don't have to pay. You do have to pay that mortgage. In a situation like that, it's how wonderful would that be if the property had any value? Sometimes it has no value because I don't want it. The rest of the title, I'm getting 50%. The rest of the title are relatives I don't even know. Well, it's still going to have to go to you, and you can quit claim it back to the estate, or you can, if you don't want it, you have to be notified. Notice is 9/10 of the law. You have to know that it's going on. They're not just going to put it in your name without telling you. That could end up being terrible. So notice is 9/10 of the law. They'll say, yeah, you are one of the heirs, and this is how things will be distributed. We're letting you know before we close the estate. And something like that. I give examples of my experience in cases that I've had because there are never two that are exactly alike. They're just different family members. It was a couple, and this happened a few years ago, that husband and wife, no children. The husband had, I think he had deceased siblings, but the wife was one of 6 Most of them were in the upstate, Greenville, Spartanburg, Anderson. And she started going downhill, and he did, they have a nephew on his side, on the husband's side, appointed him power of attorney. He was power of attorney over the husband. But then they had to put her in a nursing home because she was getting pretty off and she needed around-the-clock care. And so we had to do a guardianship and conservatorship for her. I think her name was Mary. We had to do it for her because she didn't have a will. She was a power of attorney, and he was getting older, and he didn't want to handle it all, so he got his nephew. And I expected her to pass, but she kept going. She kept going, and lo and behold, her husband has a heart attack, and he dies. And the nephew, we have to take care of that estate. Well, they left him a little brick ranch. Very modest couple, worked hard all their lives. They're probably in their early 80s. And she survived him. She wasn't here with us. And they go to check the bank accounts, and they drove like just a little old car. And it's over $600,000 in the accounts. Over $600,000. Nobody knew. They weren't big spenders. Didn't have any children to spend on. The house was nice. So we had the real estate, and we had $600,000 in the bank. That all went from his estate to her, and she was still living. There's this nephew. He's taking care of everything. He's been doing it for years, and he's the nephew on the husband's side. Husband dies. Well, she survives him by about a year, and then she passes away. Right? Holy cow! What are we doing now? We have to open her estate. We filtered everything from his estate to her estate. Now her estate's probably now $700,000 because or $750,000 because we have to deal with the house, and we'll eventually have to sell it. There's nobody to inherit it or wants it, and so the nephew thought that he was going to be inheriting big. She survived him, so the disbursement of the estate is going to go to her side family, and that includes her siblings. She had one that was still an older sister that was 93 in Florida, and she had a brother that was 89 in North Carolina, and he called me every day. When is this happening? When is it dispersing?
Oh, wow.
I was so angry because he hadn't come to visit her. He came to the funeral, but I thought, geez, he's a snake. But I said, I've got to follow the probate rules. You're going to have to wait. And I did get a disbursement where I sent in the truck. I sold him, and he got the truck. But when you're a PR of an estate, the law says you're entitled up to 5% of the value of the estate as a PR, which means you're going to get paid 5% of that estate value for the work you're putting into it. Working with an attorney or whatever, having attorney's fees, probate fees, they're all paid through the estate. It all comes out of the estate. So if you're the one handling that, don't worry that you're going to pay the bill. You don't, unless that estate has no value. You might have to pay the bill. So we're doing deeds of distribution all the time. That's just a transfer of real estate because we still have to open an estate, but we don't have anything else because it's all been taken care of. In that situation, when it came to disbursement, we had some siblings. This woman's siblings had died, but she had nieces and nephews, and it's dispersed on all that level. So her brother and sister, they got the most because they were at her generational level. She had 3 deceased sisters, and I'm sending checks to these, yahoos because they've never seen the kind of money in their life. Up in Taylor, South Carolina or somewhere. I hated it because they weren't all nice people to me. They kept hounding me, but they're not going to know what to do with it. They call me, what is it, disbursement? When geez, everybody's greedy. They didn't come visit her. This is what happens to their estate. And here's that nephew who's I'm working with him doing her estate, and he realizes, whoa, I thought he was going to survive her, and maybe he had his little green in his eyes too, because he saw what he stood to benefit. He had a wife and children, but he was out there beck and call all the time. And does he deserve something for it all? Absolutely. Absolutely. They didn't have anybody else. And he did a good job, but he was shocked that his uncle passed first. He got the PR 5% fee, but he didn't get an inheritance. So he got the 5% PR fee, so 5% of 700,000, what it was, so 70,000 would be 10%. And so he got 5%. He did get paid for all he did, but he didn't inherit that large sum the way cousins and they. Right, the wife didn't have the will, the husband had one. So if she had died first, everything would have been his estate, and then it would have been dispersed to the nephew in the way he wanted. But he died first. It was unexpected. She didn't have one. We had that guardianship and conservatorship I spoke about earlier, so they could access her stuff and take care of her. We had all that. The court said, yes, she needs this. And the husband didn't want it because he was getting older. He said, I can handle it. You can look at it. So I was working with them all. But when the husband died unexpectedly, he had a heart attack, everything goes to her. She has no will. And that's how it had to disperse. And this nephew on the uncle's side, he just got that 5% PR fee. He did not get one of those big checks that I had to get out. Correct. Correct. If you had a child,
The man died.
right,
They gotten something.
he would have.
But when the mom, when the stepmother died, he still would have been entitled to something, right? Or not?
If he could have made a claim, that's what I talked about earlier. He could have made a claim against his uncle's estate or father's estate if there was no will. He could have made a claim through the probate court, saying that there's a omitted spouse or omitted child. Sometimes when people get remarried and they don't update their will and they don't mention the child, or they did a will before the child was born, then they can file under the omitted spouse or omitted doctrine, say the second spouse wasn't included. The crazy story that there's, when I talk about life insurance policies, and I'll never forget this one from reading this case from law school years back, was a life insurance policy for $500,000. And as a young couple, they did this. They had young kids. The kids grew up, and they got divorced after 20 years. 10 years later, he got remarried. She got remarried. Never saw each other. 20 years or so. I guess I didn't make them kids. I forget the exact facts. But the point is that when the husband dies, ex-husband dies, he's married, he has new kids and everything. Never even seen the ex-wife for 20 years. He never changed the life insurance policy. First wife's still on there. They have to find her. She stays away. She gets the life insurance policy because he didn't change it. And the life insurance policies follow exactly who's listed. Current wife. Out of luck. Out of luck. So I always say check those policies. Make those people work for you. That's your policy. It's your 401k. It's your bank account. Know how it reads. Know that it's joint, whether it's with a spouse or a child. Know who your beneficiary is. If you don't have a spouse and you have those accounts and there's no beneficiary designated, then they're going to make it out to the estate, and all that money's going to be taxed through the probate. So sometimes it just depends on who holds that policy or those accounts. You can say, I want 50% to go to my spouse because it's a second spouse, and I want 50% to go to my children. You list the children. Or percentages. Some places will let you do percentages. But know those things. You've worked hard. And make your lenders or your investment or whoever holding those accounts know. And even with the state, if you're a state employee, you have mandatory retirement. They take that out of your paycheck. Make sure you've listed with the state where you want it to go if something happens to you. Also, life insurance policies with the state. Remember, just make sure you have listed on there who you want on there. It's very important.
I tried to change it where it would be split between my husband, and then it would be the other half would be split between my children. You know,
They wouldn't
they
let you.
wouldn't let me do that. Because at first I was going to do it with my divide it with my stepson, you know, and it wouldn't let me do it. And then I was like, well, maybe because I don't have all this information, maybe that's why it won't let me do it. So I tried to do it with my two children, you know, like that. And I was mad at my husband at the time. But anyway, but it wouldn't let me do that. I had to leave. It said it had to be all for him. And I was like, that just doesn't seem fair.
Is that with the state or who?
This was like with when I was doing my 401k, 403b.
And who was it with? Was it with an investment firm or?
It was with Fidelity at the time.
I'll tell you what, Fidelity's difficult. I've been banging heads with them, and I just finally, Fidelity is very difficult to work with. That's why I said check with your own whatever company holds it. You should have been able to do what you want to do. It's your money. It's your account. And you don't read the fine print when you
Yeah,
sign
because
up.
he has more money than I do, so, I
What-
mean, he ain't gonna need my money, so.
Tell them that's what, but right, but you need to tell them that or transfer your money somewhere else if they can't do it for you. It's your money. Don't let somebody else control it that way. That's what I say. I had a horrible thing, and I tell you all these examples because I guess I've been doing it long enough to have all these strange things happen. But I had a woman come to me. I think she's about 80. She's pretty spry. She's in good shape. And she had a daughter and a son. And she had a grandson who's probably 25, 27, engaged to be married. She gave him a house they were living in, put in his name. And it's about 2, 3 years ago. He committed suicide. It's awful. Awful. And so his mother, I'm dealing with the grandmother, right? So the mother steps in, and she becomes, files for the probate. I kind of help her and tell her how to do this. And you wouldn't think he had many assets, but the grandmother put the house in his name. And he had a great job at Caterpillar or BD or one of the companies around here. So he was a really responsible young man. They're ready to get married. And 6 months later, the mother lives up in North Carolina. 6 months later, grandmother comes to me and says, my daughter committed suicide. 2 suicides in the family in a year. And so her grandson, everything went to the daughter, his mother. It was divorced. We're getting a divorce. The grandmother, I don't know, God only gives you so much to handle, right? I mean, she's been through everything. We just closed and dispersed everything yesterday. It made me think about coming here and telling you the words of this woman is a strong woman. But fidelity held the accounts. And trying to explain to them what's going on. They required everything. They required that she sign a power of attorney over to me. I'm the attorney. I've never had as much difficulty getting those policies distributed with any company than I did with Fidelity. Letters after letters. It took way longer than it should have. We finally dispersed it yesterday, but we have to follow how it went. So the grandson's estate went to his mother, and then once it filtered into the mother's, we had to disperse that estate. And actually, her husband, his father of the child committed suicide, probably in the early 50s, he came in, and then she said, I'm going to give him a share too. And she has a son who's successful, takes care of her, and runs a dealership or something. But that ex-son-in-law of hers was very nice. Everybody's very nice about it, but she said, there's enough there just to get the face into. I mean, what a loss. And there was no grief. There was no, now the fiance, the young one, she was devastated. But they let her live in the house for another 6 months, and they actually gave her a little bit because she's devastated. Where's she going to start her life? You see how people work in different ways, but we're not dealing with a whole lot of family members in that situation. It's just extremely tragic. But there were tons of different children on generational levels that we had to deal with, arguing and fighting. And I see it happen so often that they can't get along, and it's just such a waste of an asset. You know that the deceased person never wanted it that way. They want everybody to be happy, get along. But I think the longer we live, and if we're blessed with children, we watch those children grow up, we know which ones are going to be responsible adults. And it's no reflection on us, but we try our hardest to raise them to be good citizens and to work hard for their money and respect their family and elders. But something comes along and you don't know what we'll do. So things up here that I think it stems back to our childhood, maybe. How much love and attention do we get? I don't know. I do a lot of domestic law as well, divorces, custody, adoption, and I do abuse and neglect cases. So I'm a court appointed. I have a contract with the South Carolina Indigent Defense Commission in Columbia. They appoint me to represent parents on abuse and neglect cases, and they appoint me to represent vulnerable adults, called Adult Protective Services. I represent them. That's when they don't have any family members, and say they fall in and somebody does a well check and find out they can't get up, and there's cats and dog feces running around, just an awful mess, but they don't have family members, so they're taken into DSS custody and they're placed somewhere. And I'm representing them to make sure that they get the care they need, or that it's just something that has to happen. We've had DSS come in and take somebody, and they're actually okay. They just broke their hip. Give them a break. They don't need to be in a home. Let's get them better. Get them back. They can live on their own. So I always have to be very wary of DSS. I hope nobody here works for DSS. They do a good job, but every now and then they're wrong. But I do the abuse and neglect cases too, where I'm representing a mother or father, and a lot of drugs in Sumter County. I represent a lot of grandparents that have moved in for custody and take care of these kids. So, yes, ma'am.
Recently, we just tore down a house on one lot. We had a business, which was a barber shop. We tore that down. As far as the deed is concerned, is there anything that we need to do to go to the courthouse and say, okay, there's no longer a building on this property? Or what do we need to do for that?
But you didn't transfer the property itself, right?
No,
So when you read these deeds, and I should have brought that sample deed today, it's a legal description. So a lot of times it will reference the meets and bounds or the survey, or a lot of these plats are filed with the courthouse. You don't need to do anything with that except to tell the county there's no longer a building there and you don't want to be taxed on the building.
right.
You're just being
So they're
on
just
the
taxed on the land, but just need to notify them that the buildings are no longer there.
Correct, because if you look at your property bill, sometimes if there's a mobile home, you'll be taxed separately from the mobile home. The mobile home will be taxed, and the property will be taxed.
Right.
If the mobile home, if it's tied in, which means it has an underpinning, it becomes part of the land, it's a different tax, and so it's done differently.
Okay.
But that situation is, if you were being taxed on the building, and your property card and your tax bill will say what the land value is and what the building value is.
Right.
If there's no longer a building there, you shouldn't be taxed on it. And you need to let the tax office, tax assessors down on Canal Street,
Okay.
where you pay your auto tax, let them know there's no longer a building there and you don't want to be taxed on it.
Okay, thank you. Another question I have is about the car titles. Should both the spouse's name be on all the car titles that you have?
That's a personal choice. That's a personal choice. But I guess in my mother's case, when I told y'all about that, it was I think it was probably just in his name because he went and got it, and I don't think she was on it. That was the problem. But if you wanted to transfer, if you're worried about those things, then I would. If you're selling it and it's going to require both your signatures on the back of that title to sell it.
But if it's R, it doesn't
If
really
it's
matter.
or, it doesn't matter. It's
Okay.
either one.
All right, thank you.
And I tell you, with titles to mobile homes, those can be difficult. A lot of people don't ever have the original titles, so we're dealing with the DMV. A lot of their forms you can fill out for all of that, and it's a headache in the process. But we try to help people where we can with those things. Taxes, though, you talk about taxes. I'll just talk about the property taxes on real estate. Is if it's your primary residence, it should be taxed at 4%. If it's a rental or you own a second property, that's usually taxed at 6%. It's going to triple your taxes or your mortgage. And I always tell people every time we go do a closing, I give them a form and I say, when your first utility bill comes that matches your name and the street address, go down and verify that you're being taxed at 4%. Ken will drive around. If they see a property listed or for rent, they're going to try to catch the owner and tax them at 6%. And then there's also rollback taxes. Say it's been a rental property for 3 years, and it's your second property, and they find out, they will back those taxes and charge you for it. So you just want to make sure you're being taxed at the right rate. Primary residence is 4%.
I have maybe another question. We have what we call the family house, which my mother and father stayed in, and we have a sibling that's staying there now. Whenever they passed away, they turned it into, I think it was real estate tax or rental property.
The 6%.
Yeah, okay, so now that my sister is staying there, is there any way we can get that changed, or does it have to stay that way?
It depends on if the property's in her name.
Yeah, property's
So
not in her name. It's in the baby sister's name.
And if she's even on the deed with others, we can show that one of those people that's on that deed is living in the property 4%.
Okay.
I've got a few more questions. No, I'm here. I'm just excited that people are asking questions and that they're here and they're learning how important these things are, because I'll tell you what, on the flip side, what am I dealing with is a mess. Somebody comes to me to try for me to clean it up. So I like the questions, and I hope that everybody takes advantage of these documents.
Okay, I'm thinking of the lady that you mentioned earlier, saying that her daughter was dead to her, but you didn't want to put that into the will. Thank you. So, say if you have a child that's not, I'm going to say up to par. he or she may be into, say, drugs or whatever, having a hard time with life itself. Can you put restrictions within your will to say, okay, little Johnny here, until he, say, maybe get himself together, give him to the age of 40 or something like that to get it together. If he doesn't, then no, I'm not going to allow him anything at all. Is that just to, or maybe worded in another way, but right now that's how I want to word it.
That's a really good question, and that's going to lead me to show you all. That's a good question. I don't ever present myself to be a trust attorney. I do basic trust, but you're talking about a trust there. All kinds of different trusts that are out there. I will do a basic general trust. If somebody wants that in their will, and usually I'm doing that for minor children, for parents, and I'm going to, let me know if this answers your question, but this is called a will data sheet, and I brought a lot of forms here. If anybody want to leave them with Ms. Graham, if y'all fill these out and bring them to my office, my card's there, scan them, send them to me. I say, give me a week to 10 days turnaround time, and I'll call you if I need more information. But regarding what you're saying, is here, you're filling out your name, address, your name of your spouse. It says executor, but we call it personal representative in South Carolina. Your first choice, your second choice, and then it has the children, name, address, birthday. They come down here, real property, and if you own any real property. If you have an interest in real property, say it's your grandmother's land, but you own it with some cousins. I still want to know what the real property is, because your interest still has to transfer. Even if we don't take care of everybody else, I want your 10% or whatever it is to transfer properly. Personal property, we talk about that personal memorandum. If you look on the second page, not all of this is going to apply to everybody. We have specific requests. If that's that great grandmother's ring, it's going to go to the granddaughter. We'll put that in there if you want. Be careful with it, but we'll put it in there. I had one man had an extensive gun collection, and he had 2 grandsons, and they were minors. But I said, well, then I want them serial, make, model numbers of these guns and who gets what. We're so specific, and he knew. I'll put it in there. We put in, if the person you're designating everything to predeceases you, such as your spouse, then it goes to the children. But if you wanted to go to somebody else, I need to know who that is. But here we'll say, guardian for minor children. If you have minor children or minor children are in your custody, whether you're a grandparent or a parent, if something should happen to you, I want to know who you want to take care of these kids. First choice, second choice. Who's going to raise these kids if you're no longer there? And it's not just a young parent. It could be a grandparent who's raising kids. If they have that custody or they've adopted, we need a guardian provision. And then trustee for children. I do that and rarely, but I do it if somebody has significant life insurance policies, they're their employer, or they've happened to gain significant assets. I create a general trust. I'm of the mind where I like to have co-trustees. Here I say first and second choice, but I always like checks and balances. I don't want one person to control all these accounts for these children. I want some checks and balances to make sure that this money goes for this child or children's future. And what I do in that is I say, all right, this trust will be there for their education. If it's used up and they go to college and we've used it all up, then it's gone. But if there's leftover, what ages do you want disbursement? How do we deal with the trust later? And I personally would say, all right, we'll give it to a partial disbursement at 25, partial disbursement at 30, 35. We're talking about, are they going to be responsible? We don't know. Maybe we want to wait until 30 for a disbursement. So at least they can get established and on their feet and do something. We all have heard stories, we've seen it on TV, where a young 21-year-old, 22-year-old gets all this money because either somebody died or a tragic event. What do? They spend it. By the time they're 30, it's gone. It's unfortunate they don't have the maturity to know. I mean, everybody loves to spend money, right? But if you're young and you don't know the responsibility you have in life or what assets can do for you and work for you, you're not going to do it. But if we have co-trustees, they're going to look out for this and make sure that your hard work for your survivors is done the way you want it to be done. It's a true gift when we leave, to be able to leave something. We don't always have to leave anything. There are 7 children in my family. I'm number 5. And my younger brothers are twins, and they were surprised. I told you they were surprised. But when my father passed away, my youngest brother was an attorney, and I was on the way to being an attorney. And so my mother was only 64 at the time. And my brother said, I spoke to Mom. I think she's going to be okay. I said, good. He goes, you know what I told her? I said, what did you tell her? And we have one brother. We always have one brother as a wayward brother. There are 5 boys and 2 girls. And he said, I looked at her and I said, Mom, spend it all. Go have fun. You should be doing this with Dad, but he's not here. So travel. Get the car you want. Don't worry about leaving it to us. There's 7 of us. We don't want to argue. Go spend it and have a good time. So, and she's very conservative and cautious, and we also want to make sure that she has enough that if we need to arrange care for her in the future, that it's there. So he's like, hold on, don't tell her to spend everything, because we're going to have to pay for that home health care if she wants it. So think further down the road. All right, spend it, have a good time, but make sure there's something that's going to help take care of you. Everybody talks about price the property into my son's name or my daughter's name, and now social service is going to come back and try to get that, and because you're trying to place it out if you have to go to a home. That's Health and Human Services that does that. I don't know a lot about that. I've never seen it happen. I've heard about it. People are scared that they're going to transfer and avoid government or Health and Human Services. And I spoke to, I remember talking to Tess Dugan. Do you all know her? Probate court. She's associate judge. She's great. She's wonderful. And Judge Atkinson's down there. Rarely did they see that. She said, rarely did we see that, where they try to go back and say, when was the property transferred? How can we get that? Because this person's in a home now and their government's paying for it. And if they transferred it out for the sole reason not to pay for the care, and the care is a lot, they may trace that. She said she's only seen it happen once, but it's a fear everybody has. I don't do a lot of that, those issues, but I do. It's a concern. It's something everybody asks. I said, they're going to have to prove it. They're going to have to prove that your intent was to get it out into somebody's name so they don't have to pay for their, being in the home, or family would have to pay. So those are sticky situations that I say, I don't worry about it because I've never seen it. That could happen. I'm also not a CPA, so I don't know, how that's going to implicate your income taxes or paying a nursing home or whatever it would be. And I tell people, if you think about nursing homes, look at them, go interview them. It doesn't matter how old you are. If you check them out around Sumter, if you're going to stick around and you think one day you're going to have to be in one, get the reputations, do your research. I ain't going in that one. Don't ever send me that one. Some of them are really good too. So just once you know how everything is, and it just gives you peace of mind. And so do all these documents. Will give you peace of mind if you have them done. If you have questions, I'm going to tell you a little bit more, and then I'll answer anything you have. So these forms are up here, and people say, oh, what are the costs of all this? Well, costs go up the more crazier Will gets. I have people who want to put all these details in there. I keep it minimum. You want to craft a beautiful will that does all these different things? We'll do it. It's going to be more work, and we'll charge more. Our firm charges $350 for each document: a deed, a will, a power of attorney, a living will. First off, I'm not going to charge anybody who's here today that will come through the church. I'll charge $250. But if you're going to want these documents and you're going to get more than one, it's easier if I do them all at the same time. I'll give a better discount. I'd rather do it all at once. If you come to me piecemeal, I'm going to probably charge $250 a document because I can't have to go back. I don't want people to be afraid of costs. I'll work with people on costs. We can do payment plans or whatever, but it's not, I'm going to reduce my charges because I'm just happy that people are here today and that they're understanding what this is about and what it needs to get it done. And I'd like to give you peace of mind because it brings me peace of mind. Because if any of your children, family members come to me wanting me to open an estate, I'll do it. But darn it, I wish they had those documents so we could have followed them closely and it's very clean. And they're because it's not. I'll turn some things away if it's too much of a headache. I had 5 children bring their mother in 2 years ago, and she was probably 65, really pretty, and she looked a lot younger than she was. And they said, no, she's early dementia, Alzheimer's, and we need to go ahead and relationship, or we need to sign a power of attorney. I said, okay, we'll bring her in. They all brought her in. They were in the waiting. I said, I need to talk to her alone. And I took her in a conference room. I brought my paralegal in. And I don't ever ask these questions to be demeaning or bad, but it's my bar license. I'm not going to execute a document if somebody's not right up here. I said, I'm just going to ask you a few questions. And I said, do you know why you're here today? She said, I do. All right, do you, so we're going to sign some documents for you that you're telling them what taking care of them. All right, well, do you know what today is? Is that okay? Is that okay? It's Wednesday. Do you know what year it is? 2012. Do you know the president is? And I could see it. And I knew. And I had my paralegal with me to be a witness. And she kind of kicked me under the table. She said, I was like, okay. I went out and told the family and said, you're doing it. You can find some attorney that will do these. I said, we got to go through the guardianship and conservatorship. I'm not going to put my name on something. And there's some attorneys that'll do that. I mean, I don't like them, and I don't really know a whole lot about done that because it's your bar license. And so I do a simple little test. I mean, I'm not going to talk to their doctor or anything, but I can tell, and a lot of us can tell, if somebody just doesn't have that capacity. That's why I want you to know what you're signing. I want to have a strong faith that, hey, I'm doing the right thing for this person, and this person's doing the right thing for themselves. I want them to understand it. You're going to get a little legal education. I want you to review it. Yeah, it's terrible to read. It's legal mumbo jumbo, but I want you to know what it means. And once you understand all, we're going to sign it. And then you're done. No more. You don't have to do any more with it. So it's the peace of mind, I think, for everybody. But I think the power of attorney is incredibly important. Just go put it in a safe place if you don't need somebody signing for you. But you're going to avoid that whole headache of guardianship and conservatorships and probate court and all the families get one and put it in a safe spot. Somebody can go file it for you at the time comes. It doesn't matter if it's tomorrow, if it's 20 years from now, as long as it was done properly. And I almost think that's more important than it will sometimes. Because somebody could live years in a demented state. And you can't access anything. And it's expensive. I charge $3,500 right off the bat to do a guardianship and conservatorship. It's two different cases through the probate. Guardianship is for health care. Conservatorship is for assets and accounts. And once one's been approved by the court and you have their order, that conservator has to do an annual accounting with probate. Where those expenses going for health care, going for mortgage, that person's taking that role on. And they don't get the 5%. They don't get paid for that. So it's when you bring one on, they're tough cases. They're necessary, but a power of attorney preempts all that. So you need to have a power of attorney. Just go file it, and it's activated. Yes, ma'am. The power of attorney, what happens? The question was, what happens to a power of attorney at the point of death? That power of attorney dies with the individual. It's gone. It's gone. It's no longer valid. And you will see cases where someone died on a certain date. Wait a minute, there's accounts for access, but the power of attorney, whoever that was, after the date, whoa, we have some problems. So, power of attorney dies when that individual dies. It goes with them. So it's no longer, doesn't exist. So that's a good question because I've seen some shady things go on. And I see so many different things, like the examples that I was giving up earlier, and it burns me up when I see that kind of activity. Because then I got to prove it. There's a hunch. The family members come and say, well, I think this was it. I got to prove it. But if there's a power of attorney and that person's taking advantage of the person who they're a power of attorney over, I can't do a lot to fix that unless the family members want to bring a court action and try to invalidate it or show that there's a power of attorney, they have carte blanche. They can do anything they want to do. It's different if it's a conservator because they're beholden to the court. They've got to file that accounting. And they've taken this position, they petition the court, and the court's awarded. Power of attorney, they can go do whatever they want to do with it. So you be careful who you want to give it to. Typically, a spouse or a responsible adult child, or even a close friend, absolutely. But it does die when the individual dies. No, and for finding the attorney. It's interesting because right now I'm working with an attorney in New Jersey. I've got one in New York, and I think one in Georgia, Ohio, where there's estates, the person passed away. If they didn't have any assets in that estate, and it's just the real estate they have interest in South Carolina, I still have to get the death certificate. I still have to get the will, even if it was a New Jersey will. South Carolina will recognize those wills. The wills that I do revoke all wills prior in time. That makes sense? So if you had a will from 10 years ago, you come to do a new one with me, and we can't find that one, I put in a clause, any will that was executed prior to this date is now null and void. It's gone. This is the new will. And that's why we date it. That's why we have witnesses. And so it will revoke any prior wills. And I think that answers your question. As far as if you have property in another state, you want to make sure how it reads and what's the situation with that, because we would have to take your South Carolina probate estate and do a exemplified copy, which is what the court prepares and sealed, and they send it to the county in the state where that probate estate is going to be open, and it goes straight to the court. I send it, it's sealed, so it shows that it's been probated in Sumter County, property in North Carolina. We need to open one in Rutherford County or whatever, and they'll open it just for transfer of property purposes. And that's what I'm doing for these attorneys in these other states is I'm opening an estate just for the purposes of transferring this property. But I tell them you're going to have to wait 9 months. We're still going to have to probate it the way we do in South Carolina if that's real property. Absolutely. And so we wait that time period. Inevitably, you've got family members that say, oh, well, we're getting it, or we want to sell that land, and they're not from here. You know, how are we going to carve it up? How are we going to carve it? Fine, go get a survey. We'll divide this land, and you people from Georgia will get this amount. But that involves a survey. Expensive. Surveys are expensive. We reference the plats, or the deed will show us what the plat is. We can go look up a plat and what the property is with the legal description. You can look all that up. That's public information. And sometimes people get scared of it. You just go to Sumter County Public Index search. You can look up who got a DUI. You can look up who got a speeding ticket. You can look up those things on that individual. But when it comes to the land records, you go to SumterCountySC.org, and it's SC because it's a Sumter County, Florida. SumterCounty.org, SumterCountySC.org, and then you go to the Register of Deeds, the online court system, the Register of Deeds, and it looks complicated, but you enter the last name, first name, or you can enter a property address, and it'll take you where the booking page is, or take you straight to the deed, and you can see how it reads. A lot of people know that they don't know how to use that, but it's all public access. Any of you can do it. I can hear you.
And that, do I have to do it again?
Okay, if it's already been surveyed, I want to see the survey. I want to see if the survey has been filed with Zoning and Planning Commission over here. And once they approve it, then it has a book and page number like a deed does. And it's in the county, so we know. You'll see where, say, somebody owns 10 acres and they want to give an acre to each child. That's fine. Is it all equal? Did you do it before? Because if they pass and then we're surveying and cutting it out, well, one child's going to say, well, they get the one that's on the pond and I get the one with the pine trees. All right, are we going to have to get an appraiser too? I mean, that's what we got to consider. So if it's surveyed and you're cutting it up to give to people, then it's going to get its own tax parcel number, which is how we identify property. You'll see it on your tax statements. It all has to go through zoning and planning, so it has to be approved by them first. And most of the surveyors are reputable. We know who they are. We work with them. We see the plats. They do the surveys, and then they have to file it at the courthouse. It gets approved by the county, and each acre gets assigned its own tax parcel number, and being the person's name, there's a legal description. Typically, it will refer to our legal description will refer to the 10-acre tract, and then you'll see big letters say less. And we start cutting out until we get to individuals who can identify exactly which property it is. I like using recent surveys, but I don't want people to have to go get a survey if they don't need one, so I'll reference the plats in the courthouse. And if they're fairly recent, I don't think there's a need to spend that money. I will tell you that surveyors do charge a lot more when it says acreage. And they go, you have appraisers. What's the value of the land? I had a 70-acre tract out in the country that a woman from New York had contacted me about, and she had a very large African-American family, and most of them weren't in agreement. But they had to get it surveyed because they knew that there was different values. Some of it you could farm, some of it was swamp. So that's up to y'all. I can get you a survey, but I don't do all that. How y'all want to cut it out is up to y'all. I can quiet title legally, so it's a marketable title, and that property has its true value. Because the more people that own that property, the commercial developers could be interested in getting it. You know, the only thing to do with it until it's cleaned up. And you probably hear about that all the time. It's a very common issue. The Center for Heirs Property Preservation has a website, and I would encourage everybody to just go to that website. And it's a lot about what I'm talking about today. They have real life stories. I think PBS did a documentary on one woman who she married an Italian, but it was this beautiful property on Watermelon. Y'all know where Watermelon is, right on the river down by Charleston. And she had the resources. She had been a model and an actress, and she was a beautiful African-American woman. Came back. She knew she had all of these families. So what she did was she started the quiet title action. They did a documentary on it. I can't remember the name right now, but it's on the website. And she had the resources. She had the money to do it. And so what she did was she kept the main acreage for herself, and then she carved out certain areas and put cabins on it for all the people who really, y'all come use it whenever you want, but we're going to save this and keep it in the family. She had the resources to do it. It's expensive. And when I tell people, you want a quiet title action, what are we talking about? How many generations? How much acreage? Who all is involved? Where all did they live? Do we know the birth dates, the death dates? Was it probated in New Jersey or was it not? I got to get all that information. And it's a lot. And so I say, if you want to start this, it's going to require a lot of patience. I love studying other people's families and see how the trees go. It's fascinating to me, but I got to turn that into a legal document. And so it's interesting how it all goes. They're big cases, and I usually say, you're going to be expected to $7,500 retainer because I've got to order a title search. And then I got to piece together the family tree from what you tell me. I have a lot to collect, and I'm going to lean heavily on you. But it's time consuming. Once we file in the court, we're going to have to refer to the master in equity, who is the judge in Sumter County that handles all land transactions and litigation. That was Judge Booth. Dick Booth. I don't know if you'll ever heard that name. He passed away a few years ago. He was a great attorney and a great master in equity. I clerked for the master in equity in Charleston when I first got to law school. His name was Michael Scarborough. He's still the master in equity there. And that was 2007. And they do all the sales, on the courthouse steps, the foreclosures or tax sales. I've heard about this. There's a list that's published. But what we started seeing back in 2007 was when the economy started going bad because all these mortgages started falling through. And it's the first time they started seeing houses that were on Keel or Seaver or Sullivan's Island. They were going into foreclosure because people couldn't afford what they had bought. And that's when the crisis started. And so then you see, all the vultures come in and they want to buy it at the courthouse steps, banks selling it, and they're only willing to take this much as far as what's left on the mortgage. Some of the banks got smart and realized, we're going to go ahead and renovate the kitchen and then go sell it on the courthouse steps, and we can ask that much more. So that was what was going on during that horrible time between, say, 2006, 7 to 12. You can see it everywhere. Now our issue is we do a lot of real estate, like I said, there's no inventory in Sumter right now. It's really short, really low. If you go to the MLS, not many houses, and you think, what's up with that? Because we see all these new developments being built out towards the base. Well, many factors. One, usually they do the change of command in June. So all these new people are coming in, we're bracing for all the closings we've got to do. They didn't do that during the pandemic. It's all been coming in and trickling. You've got all these manufacturers that are building here, like Continental, or they're coming in. You see it all growing up right up from Charleston. And their bidding wars going on. Every house is even never even explained. Because there's nothing out there. You also talk about certain stimulus checks that help people. Well, it's not all of it's going for bad. You're not all spending it on drugs and I can buy a house now because I can have to now. So there are a lot of reasons why this is happening right now, and it'll probably stay strong. You go to Charleston. Have anybody driven to Charleston lately on 26? Have you seen how they're clearing all that? Do you see where Volvo is now? They're going to make it 6-lane. That's what they're clearing, to make the highway bigger. It's part of the incentive getting Volvo down there. I say this, I'm not involved in it, but I know that's what's going on. You have Mercedes there, you have Boeing, you have Continental here, and I know a little most people because my wife actually works for the Sumter County Economic Development Board. So she works in that funky building right at the corner of Liberty in Maine, that was controversy for a while. Everybody wonders. I'm on the Historic Preservation Design Review Board for downtown. So we have to approve all the architecture, signage, colors, windows. And when that one came along, it caused a little bit of an uproar because I thought it was just too modern. And I spoke to the architect. He said that we're originally going to do a really large old Charleston single house. Ones have the porches on the side. You see typical Charleston house. And that's just making us look old and dated. And his concept was, if you look at it, that building from straight on across the street, it's a modern Charleston house. It's got the side porches, but we want to be able to show to the world and all these CEOs from other countries that are thinking about investing here in jobs that we're keeping pace with the world. We have it here. It's going on. And look, we've got Continental. I think that's going to be a good thing. They're in phase 3, providing jobs. Charleston's going to grow all the way up here. The research, they say, is the fastest growing area of the world right now economically between Brunswick, Georgia, and Wilmington, North Carolina. It's going to reach up here eventually. I mean, you look what's happened in Sumter in 10 years. How things changed in 10 years? It's going to continue because a lot of people are moving south because temperatures, the taxes are a fraction of what they're paying in New Jersey and New York. I see it everywhere. They're coming down. It's happening in Charleston all over the place. My sister went into a restaurant just the other day, and she got married and kind of lived all over the world, and then came back. And terrible divorce, but she's been back for about 8 years now. And she said she walked into a restaurant, and the hostess said, "Hey, where are you from?" And she said, "She goes, oh yeah, where are you originally from?" And she said, "Here, I grew up on St. Thomas." She said, "Oh, I've been here 3 years and I've never met somebody from here." It's Colorado Blades, Hawaii. They're all over New Jersey. They're all over Charleston now. But I think that this community is really, it's a close community. It reminds me of Charleston when I was growing up. I mean, people work together still. It's a small enough where you can run into somebody at the grocery store maybe. But it's a supportive community. But that's just it, is that it's inching up this way. This place is growing. That's why these documents are important. These documents are important. You work hard. I think everybody should get them done. I'm going to leave these here today. And you'll contact me. Feel free to contact me. Any questions you may have after, if you don't want to ask one in front of everybody, shoot me an email. I can answer this a lot faster than I can a phone call. This Graham knows that. Because I'm back to back. I try to answer all my emails I can get to quickly. It's just the phone can be hard if I'm back to back or I'm in court or whatnot. But I want to say thank you for inviting me here today. Any questions? I can go all day long if you wanted me to. I like this stuff, and I really want everybody to just know the importance. I mean, I can't tell you enough how you will have a peace of mind when it's done. And you don't have to talk to all your family members about it. We all have a wayward family member. We want to make sure that one doesn't cause trouble for everybody else when we're gone. Or maybe you don't, but you still want your stuff to go where you want it to go, and have some control over that because you worked hard. I do like all this. Question? I can go to family court too because I do a lot of that. So whatever you want, you can ask me. But please feel free to contact me. I've also left a card, and there's some pens if y'all want the right pens. But you can fill them out, take them with you, keep the pens. We have now just gone to a no mask requirement policy at the office. But I always enter a room with one on, and I check with everybody first. I'm vaccinated. I want people to be comfortable with what they're doing. Come into my office. Sherry is our receptionist. She can get you on the calendar if you want. She can look at my calendar and yours and match up when a good time is to come in. Usually I'm doing a consultation to talk about this stuff. You all know it. You can fill it out. I'll call you, or my paralegal will call you if we need more information, or we're wondering what's going on there. The important thing is you know what that document says and that we've done it the right way. And you proofread it. You understand. I've spelled names correctly. I might have a personal print on here. That's fine. I just want to make sure it says what you wanted to say. And I'm not going to sit there over your shoulder and read it. I'm going to leave you in the room alone and tell you what it is. Read it. Mark it up with a red pen. I don't care. I'll go make the edits. I just want it done and done the right way. All right? Yes, ma'am. Anything else? Thank you all for having me here today. I appreciate it. It's an honor. Yes, ma'am.
Thank you so much for all that valuable information. For myself, I know that having a willpower of attorney and health power of attorney is very valuable. So I'm a witness to that. We want to thank you so much for coming today, and we want to present you with this token of our appreciation, and we really appreciate you coming. We see that our pastor is here. If you want to come and close us out. Okay, he said he's fine. Okay, thank you so much again. We have the information up here if anybody's interested. So please feel free to come and fill out the information and get it back to him. And thank you again so much. So just let us stand for a quick word of prayer. Dear Heavenly Father, we want to thank you, Lord, for this day, dear God. We want to thank you for the information and thank you for the attorney coming to give us the information that we need to plan for our life events, dear Heavenly Father. You are a God of decent and in order, God. We want to be in order. So, Lord, we give you all the honor, the glory, and the praise. In Jesus' name we pray. Amen. Thank you so much. Very, very good. I like it.
Testing one, testing, testing one, testing, test one, testing. See you later. Test one, testing. I don't understand something. Something is up with this. Test one, testing. I know, but I'm not registering here. Maybe. Test one, testing. Test one, testing. Test one, testing. And see, I'm not right there. It's not on this channel. It's actually on this channel. Test one, testing. Test one, testing. Test one, testing. See, my signal meter is not working here. Test one, testing. Test one, testing. Test one, testing. Test one, testing. Test one, test one, test one, testing. Test one, testing. Test one. Test one, testing. Test one, testing. Test one, Testing. Test one. Testing. 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 Test one. Testing. Test one. Testing.